All right, good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, April 6, 2023. We are on voting list number 26, and we're going to start off actually with, is this you, Josh, with House Bill 808?
House Bill 808 is the cross-file to Senate Bill 859, which is the Reproductive Health Protection Act. The bill generally establishes protections for information related to legally protected healthcare when that information is sought by another state, and prohibits the state of Maryland from taking specified actions against providers and people who assist in the provision of legally protected healthcare.
They conform to the Senate amendments.
Correct. They adopted the same amendments that the Senate did.
808. It's the cross file of 859, Senate Bill 859, which
Which
Yeah.
I voted for.
yeah. So motion for favorable. It's been seconded. So is everyone okay being recorded in the affirmative, or the same vote that you took last time? So the same vote last time. Got it. So that's McKay down. Yes. All right. House Bill 808 passes 10-1. Yes. I mean, sorry, 9-1. No, actually, that's 8-1 because we have actually it's 7-1.
Are we going for
We're losing people. 8-1, 8-1. It's a game of attrition here, man. That's awesome. All right, which one is that?
HB 186.
All right, we'll go to House Bill 186, just it has to go to budget and tax, right?
HB 186, this is the bill titled Victim Services Program, supplementing federal funding and support the Victim Services Stabilization Act. It is the cross-file to SB 148, which passed the Senate 45-0. It is, however, not identical to SB 148. The House version, B&T Council advises, has a technical amendment that clarifies that funding cannot be used for capital projects. Evidently, the intent is to put on an identical amendment to the Senate version over in the House.
Got it. Can we move the amendment so we?
We don't need
Oh, we
to.
don't.
It's
They're gonna put it on.
the House actually put it on for us, and then
So it's just straight favorable.
Yep.
Discussion. Motions for favorable. It's been seconded. Everyone okay being recorded in the affirmative? All right. Passes unanimously. Excellent. We'll now move on to Josh with House Bill 20.
House Bill 20 generally prohibits an adult who is present and supervising a minor from allowing the minor to ride a horse in specified areas unless the minor is wearing properly secured a helmet that meets or exceeds the standards of the American Society of Testing and Materials for protective headgear used in equestrian riding.
Discussion. Motions for favorable. Second, is everyone okay being recorded in the affirmative? All right, House Bill 20 passes unanimously. All right, we'll now go on to Shamari with House Bill 34.
House Bill 34 requires the district court within 60 days after the resolution of a failure to pay rent proceeding that did not result in a judgment of possession to shield all related court records. The bill also authorizes a court to shield all court records relating to a failure to pay rent proceeding that results in a judgment of possession on motion of a tenant and a specified requirements are met. In addition, the bill prohibits, with limited exceptions, a landlord from increasing rent solely because a judgment was entered against the tenant in a failure to pay rent action. The bill's shielding provisions apply prospectively only and may not be applied or interpreted to have any effect on or application to any action initiated under 8401 of the real property article. That's the failure to pay rent statute before October 1st, 2023. The bill's provisions related to the development publication of a specified form take effect August 1st, 2023. There is a small technical change, a typo essentially, where on page 4, line 6, it says seal instead of shield. That should read shield. And so the sponsor was asking that we amend that one word.
So you can just do that by voice, right? All right, so Senator McKay.
So, all right, I get the part of not increasing the rent solely because the judgment was entered against the tenant failure to pay rent. So a landlord can't see the other part. The landlord can't see if somebody has gone to court and not paid their rent.
Well, if there's no judgments for possession, then or for whatever reason, the case is dismissed.
So the person who pays 1 month, skips 2, go to court, somebody helps them to get the rent, which is proper, and then repeats this on a regular basis, the landlord can't see that this person has trouble paying their rent?
So in your example, so they would have to shield.
Which is
within
real life.
60 days. And so.
I mean, I don't know what the difference, I understand, I'm not arguing with you, but Mr. Chair, I don't know what the difference is when you do an application and you're figuring out where your revenue is coming from and all that kind of stuff, and we should never discriminate against somebody or where their revenue is coming from or anything, source of income's coming from. But I have a hard time believing that we really want to pass a bill that a landlord couldn't see that somebody, good, bad, or indifferent. I'm not saying that they're not a good person, but past performance is an indicator that maybe this isn't a good fit for them. Maybe they need to have a place that has a lower rent. I mean, I don't understand the purpose behind this.
So Shamari, how many rights of redemption do people get in a calendar year?
So you have 3, Baltimore City is 4. And so, if you're doing this often and, it's resulting in judgment of possession and you redeem by paying the landlord the outstanding amounts, and you do that within 3 times within a calendar year, then a landlord can say, no more redeeming the rent, and you can get the property back. The landlord can.
So
What about
and then the second, just real quick, just
4
before,
times
in Baltimore City,
In
in
Baltimore,
Baltimore City?
three statewide.
And how many months are there in a year? So
Well-
every 3 months.
But so then can you walk through the process of this? Because it's not an automatic, there's a process, right? There's a process that the tenant would have to go through.
for
So to have these shielded.
yes, and so if you look at the bill. And so in page 3, sorry, page 3 of
Page
5.
3.
And so the court would have to automatically shield if they didn't result in judgment of possession. But I guess what's your question is, would someone be able to do this over and over?
I just
within the 60
think
days?
that good, bad, or indifferent, and I'm somebody who is a second chance guy. My apartment complex, not complex, the unit that I have is filled up with second chance people. I give second chances all the time. But I'm certainly not going to put somebody in who can't afford the rent that they may be at. Maybe there's somewhere I can work with them. I get it. There's bad actors out there, but someone's got to walk in the shoes of a landlord.
So I hear what you're saying, and we had this debate last year. And the only reason is that I'm okay with this is because I know you get 3 bites of the apple, a year, but under this bill, you have to wait a year before you can have the records relating to the underlying matter shielded. And it's not an automatic process. I think it's a pretty laborious process, and you have to wait a year. So, all things on balance. I mean, I was where you were last year, honestly, on this. It's a longer process. It's not automatic. You got to wait a year for that.
But how does that help people? a longer process. How
Well,
does
just
that, how does that help that person?
if it's further, if you're not if you're not a frequent flyer, this has happened once and you're still looking to get a place, you know, you can have this shielded and you can move on with your life without having it impact your ability to move around in the future. So I think it helps the people that are actually not, you know, frequent flyers in district court, you know, for this, but
Okay, thank you.
Thank you, Mr. Chairman. So my question in looking at this is, we just passed a bill about shielding for DWIs. And now we're putting in legislation to shield non-rent payment. I'm baffled. I don't understand how this has any, we're going to shield somebody. And under the scenario that Senator McKay gave, you said it's up to three times a year across state, 4 times in the city of Baltimore.
That's if there's been a judgment entered against you.
So if
A
there's
judgment
been,
of possession and a failure to pay rent.
you mean 4 times
So
a
this
year for
bill-
judgment to pay rent or?
In Baltimore
So
City.
that's what I'm saying. So help me understand this. In the scenario that he gave, you pay 1 month's rent, you go 2 months, don't pay. You go into court. And then can the camera go way out? I mean, isn't this a 2-party consent state out there? The gentleman out there keeps video and everything.
Yeah.
The gentleman in the
Yeah,
gallery keeps
yeah,
video and everything.
okay. Because that's if you just. Well, yeah, but also Shamari, just, yeah.
No,
We
we
can
have
just-
it out there that there's no cameras and no video stuff. I thought it was posted.
Yeah.
Yeah, this is up for, this is live feeded. So my point being is that we have, someone can go and make rent 1 month. They can go 2 months, miss rent, have a court date come up, right? They get the process unfolds, they come back, they make another month's rent. It happens again, they go 2 months, then they end up in court again, then they make the rent. This literally takes you the full length of a year if they did it every 3rd month, like the scenario he gives. And we're going to shield this for the purposes of what? People should be, if you don't pay your credit card bills for 2 months in a row, it goes on your credit report. If you don't pay any debtor for 2 months, it goes on your credit report. But we're going to give a shielding mechanism for people that are not credit card companies, who are small business owners or have multiple units, a couple units that they rent. And we're not going to allow them, we're going to allow their tenants to be shielded as bad actors and taking advantage and manipulating the processes that are in place by shielding that bad behavior and rewarding them and penalizing and costing the owners more because they have to file the court work, they have to file the paperwork, it has to be served, they have to go through a whole process every 3rd month. And we're saying that they have no way to then add any fees onto the rent to recoup the costs associated with this on top of shielding the bad actors' behavior. Am I missing something?
I'm gonna look and verify really quickly, but I believe part of the right of redemption, in order to redeem, you would have to pay those court costs as well. But I'm gonna verify that as well.
They have to pay the court costs back? Okay, so other than that, is everything else correct? That they could do this 4 times in a calendar year in Baltimore without with it all being shielded and without being able to.
You
get
have to
evicted?
wait a year. So let's say you got a judgment on January, you'd have to wait a year to have that one shielded. This doesn't touch your ability to redeem at all. It just touches the shielding of this judgment but you have to wait a year after the judgment to get it to apply, not even to have it automatically happen, to apply to get it shielded.
That's if the judgment. was
If there's
entered.
a judgment.
But if you redeem,
If you redeem,
then
you can continually do this cycle
every 60 days or so.
every 60 days or so. That's for any small, property owner that's doing this. I think this is wholly unfair to them. So, yeah, I mean, they have bills to pay. These aren't like large corporations or big credit card companies. And we don't allow, if we're gonna do that, why don't we just shield everybody's credit card debt too? Because that way, anybody can buy what they want and there's no accountability. That sounds like a great idea. I appreciate it. Thank you.
I just want to understand the problem we are trying to solve. That's what I want. I mean, I don't remember the bill hearing, so why are we doing this? What was the reason we were doing it, and how large of a problem is this?
So I believe there were some advocates, they testified that in order for people to be able to find affordable housing, this was important. The same way expungement or shielding of criminal records, helps people try to get jobs. So that's the main justification.
But I think if I read the shielding laws correctly, my understanding is you can only do that once. So I don't know if there's any limitation here on whether you can for the entirety of your life going in and out of paying rent and doing the rights of redemption and then seeking a court's shielding. And I also don't understand what can a judge take in. I think it's discretionary, right? I do think it says a court may shield. So I assume there must be some kind of.
May shield if there's been a judgment,
Oh, okay. And then must if
there's no
so
judgment.
there's mandatory.
And not all rent proceedings end with redemption. There
Right.
may be other reasons for cases to be dismissed. And so that's probably the one that occurs most often, but
I mean, I guess I would be more comfortable if it was all discretionary to the judge so he could determine what the circumstances were, because I think what we did with the shielding on I've forgotten how we did the DUIs, whether that was, it's an application. I don't know if we mandated that they be shielded, but in any event, when I read the shielding laws relating to criminal conduct, it seemed to me they said you could only do that once.
that may be sealing, or I'm not sure which
Okay.
one you're referring to, but if the legislature creates a shielding right under this bill, then presumably you'd be able to shield as long as you meet the
So you
requirements.
can keep doing it and doing it. All right, thank you. Interesting.
Okay,
Yeah. All right, let me.
so as is frequently the case in these landlord tenant bills, this bill is brief but very complicated. And so it establishes two ways or two circumstances in which you can get your the court records shielded. First, if you win your if your case does not result in a judgment of possession, in other words, you pay the undue rent, the back rent, before the court enters an order granting possession, then the court shall seal the records within 60 days after the final resolution. If the case goes all the way to the point that the judge enters the order of possession, then the court may shield the records, although the language in here suggests that the court pretty much has to seal the records if there's good cause shown. And that you have to wait 12 months to get that done. So it's very complicated, but essentially what I have let me put my cards on the table. I have no problem with shielding if it shields the records from a prospective employer. There's no reason why a tenant who has trouble paying the rent should not be able to get a job because he's had trouble paying the rent. What I object to is the shielding of the records as far as future prospective landlords are concerned. Because a landlord who is asked to rent property to that tenant ought to have the right to know that in the last tenant situation, the landlord had to go to court again and again and again, month after month after month to get paid. So if I read the other day, the state shielding law, there are lots of exceptions to shielding. If we could adopt an exception to shielding, which would apply in this situation to landlords, I could support this bill, but not if the shielding applies not only to prospective employers, but also to prospective future landlords. We have a shielding law, which has all the exceptions to people who can get behind the shield. If we add another exception, there's already 8 or 9 of them. If we add a 10th exception there that says in a situation like this, the landlord can gain access to these records. Prospective landlord, I could support the bill. No, as I understand, the purpose is to protect you from employers. Well, then that's wrong. That's wrong. A landlord should not have to take a tenant sight unseen. Yeah.
Have to adopt that amendment. Can we just adopt that amendment really quickly? It's the ceiling, vice shielding. Is everyone okay adopting that amendment? All right.
Thank you. The question was raised as to what problem it's solving, and I see the best example that I've read, but I do have a question about it. This is from the Attorney General's office in support of the bill, and the last paragraph records House Bill 34 seeks to break this cycle of housing insecurity by sealing court records from a failure to pay rent proceeding when a judgment of possession is not awarded to a landlord, thus limiting the dissemination of inaccurate or incomplete information to landlords that would create barriers to tenants seeking housing. Again, an example of it seems that the problem is bad information. Can you give me an example of what kind of information that one would be able to put out there that would be inaccurate or incomplete when it comes down to did you pay, did you not pay? So that seems to be the problem that it's trying to solve. I agree. I just want to see what example, how do you get on someone's record information that is inaccurate or incomplete information to landlords?
So all the court record shows is that there's been a failure to pay rent proceeding filed against you. It wouldn't show, whether the circumstances, maybe it was a mistake on the landlord's part, maybe they got the wrong unit. Like a lot of things can lead to, a civil process.
Okay.
And so, the testimony was that this allows this non-judgment, this case dismissal to not be used against you when attempting to obtain housing.
Okay. Thank you, Mr. Chair.
Thank you. Thank you, Mr. Chairman. And I actually appreciate Senator Muse's question because I think that was really clarifying. And I also was pulling up the letter in the file from the Maryland Multi-Housing Association, which I think also was really helpful in explaining this to me. It thanks the sponsor for working with them to getting the amendments they needed related to rent escrow, which were adopted in the House, and also says that they have no objection to shielding a landlord-tenant action if the final resolution resulted in a dismissal or order for the tenant in a judgment of repossession. So now they're favorable in support of the bill. And I looked up sort of, the House vote on this was roughly party line. And I think to the comment I was making to Senator West, sometimes we have these issues that are philosophical in nature, and I don't think we're going to reach consensus on this one for me. And I understand the arguments in support of people who have, who are owners and have the ability to earn revenue from renting their property. And it's the American dream, and we all have the right to do that. But at the end of the day, for me, this is a call of sort of the little people who are struggling need a fair shot. And I think we heard a great explanation based on the Attorney General's letter from Senator Muse as to why I'm going to be a yes on this. Thank you.
Just wanted to point out the trade associations that generally come out against these types of bills. Regional management is favorable. Multi-family housing, favorable. Apartment and office building, they gave information. I'm not, I mean, if there was an issue, I'm sure they would have alerted us to that. I too, we voting favorable on this.
Thank you very much, and I appreciate the dialogue back and forth. But what myself and Senator Folden talked about had nothing to do with the big landlords. We are talking individual landlords. Hey, you want to put an amendment on here that says you got to have 100 units or more? Go right at it, because that seems to be where your bad actors seem to be. I don't mean to be shadowing. Okay, so maybe it's 100 units or more. That's who you're. The case scenario that we laid out was small independent landlords. And, you know, in the landlord tenant agreement, what is the number one goal of that agreement? To me, it's an exchange of goods for services, and how you're going to be able to rent here, and you're going to be able to pay money to rent here. And if we're shielding the ability for a past behavior that has 3, if you're in other places, 4 in Baltimore City, how is that fair to the small landlord who might have a mortgage that is basing everything off of the cash flow? And the last thing I'm going to say is these are civil cases. So aren't civil cases normally sealed, not shielded? So are we starting a new precedent of doing shielding for civil cases? Are we opening up?
So under the rules, you can shield, you can apply for shielding or sealing. And so sealing is a little different in that it's generally like case specific and it's not of right. So if you want to have it sealed because, you know, maybe you're a witness in the case and you don't want it to, you know, it to be known and you can show a court for good cause. Shielding is more broad, and it's when a court is not available for public inspection, and the rules and the law sets out situations where a case can be shielded. And so this would.
But talking about civil cases, aren't they normally sealed, not shielded?
You can apply for either one. It depends on.
Well, what is the precedent? I mean, that's what we do in our. So, okay. So. Okay, so this would open up a whole new can of worms. I mean, I'm no lawyer, but really, are we going to go down this road? Thank you.
And I understand where you are as well. I'm a landlord, although my buildings are commercial and leasing, it's different. And I don't think this applies to me, but I understand the debt that you have if you're leasing a building, blah, blah, blah. You made a suggestion, and Mr. Chairman, I'd like to see if we can push that suggestion for an amendment, and the amendment may have been, can we find a number that won't hurt the smaller landlords, be it 20 units, 30 units, something that we can agree on there that would not hurt, you know, smaller, those who don't own as much in the big apartment buildings, fine, let them get away with it. But would that be a possibility, or something you want to discuss further, or just put some kind of limit so that if you only own 2 row houses, that you could lose that in 3 months. So, so I understand that. And again, although this doesn't apply to my situation, I can see a situation if one of my, you know, in a larger space decided to just not paying, and then another did that, then I've got some problems. But I understand fully and am in full support of the bill and the intent of the bill. I'm just looking to see how what I am reading is really it really sounds like it's protecting us, month to month, or, a year lease, and what happens. Is there a number that we can agree on that would be at 20, 30? I don't, what's considered small, who would really be in jeopardy?
I'm trying to get an answer to that question, where we usually draw the line between the kind of the more mom and pop and the more.
Right,
the larger.
exactly.
So
Exactly.
I'm trying to get an answer right now.
Okay, thank you.
Senator James.
I just want to echo what Senator McKay said, and thank you so much, Senator Muse, for thinking about this and really responding to you, Senator Kelly, that you want to help the little guy. So you know how in this country, we have far more small businesses than large. It's absolutely true in the landlord-tenant situation. I'm a little landlord, and every dollar matters because I am paying on a mortgage on my farm. So there's so many people that are small, and if we want to help little guys, we've got to be thinking that tenants aren't the only little guys in the country, right? I've noticed that a lot of our landlord tenant bills really are frustration with large corporate type landlords. And we're really ensnaring all the mom and pops that really should be in our thoughts and our consideration as well. So I would like us to start thinking about that every time we do a landlord tenant bill, to kind of think about the difference between the larger ones and the smaller ones. And it's the larger ones that are causing the problem. So let's not harm little people, either landlords or tenants. So I hope we can work something out, Senator Muse.
Sorry, this conversation could go on forever. And I just wanted to loop back to what I was saying, because when I was referencing it's the American dream, I was talking about the little landlords. Like, I dream one day of being someone who could have a second unit that I could rent out and earn a profit on. I dream of being a capitalist. There is risk associated with the capitalist dream, right? And this is a conversation that we have had when we've talked about discrimination in housing. I do remember the same idea coming up of setting it maybe at 5 units or something when we talked about, can you discriminate against people with disabilities? Can you discriminate against people of color? Can you discriminate against LGBTQ individuals? I don't remember where we landed, but I'm going to guess we did not make an exemption for the smaller units in that space. But you might maybe look there. But I would just say, while I am very sympathetic to the concerns that are raised, I think that there is a huge population of folks who would consider being the person who has a second mortgage that they need to pay to be having made it, right? So let's just not forget that most people are not in that position and only dream of being in that position one day.
Mr. Chair, I take issue that my objection is being portrayed as anti-LGBTQ. It was received that way. It was received that way. You may not have wanted to pitch it that way, but that is how it was received. It has nothing to do with the pigment of somebody's skin. It has nothing to do with their gender. This has to do with
having worked with and
character
knowing
of
you both.
somebody.
I understand that you never would have portrayed it that way, and Senator Kelly never would have. She did not. I mean, she speak for herself, but I know her. That was not her intent. But yes, yeah, go ahead.
I'm so sorry if that is how it came off, Senator McKay. That was absolutely not my intention at all. I was referring back to a time on the Health and Government Operations Committee, maybe 10 years ago, with a whole different set of stakeholders. I completely understand where you're coming from, and that's why I was starting my conversation with referring back to my respect for your understanding of the American dream, and you're, absolutely having no ill intent whatsoever. So I apologize if it came off that way. I would never have ever have said that about you. I know your heart. Never in a million years would I have meant to imply that.
That's 100. Yeah. Thank you both. That's right. All right. I'm going to hold this because I do want to do more research. Senator McKay, Senator Muse, and Senator James brought up some very valid points. And I think we've done this in areas of law with like 5 or more units, 3 more units. I want to get some more research on it because we have drawn that line between large and small. So always balancing interest and equities, trying to make good policy. So I'm going to hold it. We'll come back again. We're going to vote at least once more today. So we'll hold it. while I do that research. I got one more vote and they'll do the concur. I'll concur. So now I want to go on to Shamar. We're sticking with you. We're going to go to House Bill 127. Yes.
Before you go back to that, I wanted to be recorded in agreeing for House Bill 808.
Yes. Oh, yeah. Yeah. Got it.
Mix.
You don't have to be in the room when the rest of the committee votes. Please, I want to see that. I don't think that is the rule. I mean, I would love to see that in writing. Always wrong. Yeah. That's the rule. Your rule is the law. Okay, I'm glad we have that. I'm glad we have it on all.
House Bill 127 prohibits the district court in aid of enforcement or execution of a money judgment resulting from certain small claim action from ordering the appearance of an individual for an examination or ordering an individual to answer interrogatories.
Motions for favorable. Is everyone okay being recorded in the affirmative? House Bill 127. All right. Bill passes. We've got Waldstreicher, Sidnor, West, Muse. Care to weigh in, Senator Folden?
Weigh in about half hour.
Senator Washington is up. Yes. Senator Kelly. Senator Carter. Senator McKay. All right, so what's the final count?
Is it unanimous?
Yeah, well, he didn't vote.
Well, he didn't
Okay.
say that he wasn't voting.
The bill passes unanimously. All right, Senator, yes, go ahead, Senator Muse.
I have served on this committee through three different chairs. Frosh, my buddy from Montgomery, from Baltimore County, and you. 20 years ago, this was the rule that if you miss, and I want to say it so that no one who is listening it by any other way would think we just made something up for a bill. 20 years of my time here, the rule has been the same. If you're on the committee and you come in and you're not changing the vote when it's not 5-6 and you come in and you 4 and you change the outcome of it, you can have your vote recorded. That's always historically been the rule for at least 20 years back, and 3 chairpersons who I've served through. And I just want to make that.
Thank you for that, Senator Muse. And also, look, I mean, people have been in hearings, people have had delegation, and people have been doing other work during voting sessions, have come back and said, hey, look, so it's I appreciate that. Thank you. Okay, so House Bill 123, we're going to go with Josh.
House Bill 123 is an emergency bill that reestablishes the authorization for a plug-in electric drive vehicle for which a permit has been obtained from the MVA to use HOV lanes regardless of the number of passengers in the vehicle. The authorization will expire September 30th, 2025.
All right, motions for favorable and seconded. Is everyone okay being recorded in the affirmative? Everyone who's present and on campus? All right, but the bill passes unanimously. Thanks. All right.
Not pass unanimously
Oh.
because we are missing a member.
But it passes unanimously for the people that are present. The final bill today is going to be HB 70, and then we'll get over to the floor.
So I have a concur-
Not today, but we got to do some concur, not concurs, but House Bill 70, and then we'll move to concur, not concur, so we can get over to the floor.
House Bill 70 requires the Department of Transportation to implement all possible incremental and near-term safety improvements as soon as practicable when a new approved pedestrian or bicycle safety construction or improvement project is projected to take more than 12 months to complete, the bill will take effect June 1, 2023.
I think I asked the question at the hearing, whether this would have affected the lower crossing over the Potomac River, where there was a huge financial disparity between building a bridge without a pedestrian crossing and building a new bridge with a pedestrian crossing. I'm not sure I ever got an answer to that.
So real quick, this bill is substantially reduced from the original bill that we had a hearing on. And so I don't know if I was actually in the HB 70 hearing, if that's what you're referring to, or you're referring to the original Senate hearing. But the bill only applies where they put in the 6-year CIP,
What's the CIP?
the capital improvement project, a pedestrian improvement. It does not require them to put that in, but where they do put it in, it basically says, if you're going to do this improvement in the long term, you should consider making some short-term and temporary improvements in the meantime. In other words, you have identified an issue, you have come up with a long-term solution, but that long-term solution will take a while. They are not required to come up with that solution or implement that solution, but if they come up with that solution, then in between when they identify the problem and build the solution, if there is a temporary opportunity to implement that solution, that they shall do so.
And this is without regard to cost. So if there's a temporary way of implementing the solution, even though it costs $80 million, they have to do it under this bill.
No, it does not. So it says shall implement all possible incremental near-term safety improvements as soon as practicable while maintaining each project's priority ranking.
I don't
Here's
hear
what-
anything about cost in there.
Well, I think
So-
that's what incremental is saying. Here's what this is doing. So in my district, and this is the county government, not the state government. I'm just using this as an analogy. Before the county government puts in some, sometimes they put in these road diets where they take the curbs and take them inward,
Mhm.
and then the road is more narrow. Before, that's expensive when you move everything in and then you got to put fill dirt in between. And what the county does in the meantime is they put flex posts where the new curb will be until the new curb can be built. These flex posts are a piece of plastic. They cost less than $1 each. And so what this bill is essentially doing is saying exactly what your county does and my county does. These short-term temporary solutions should be utilized where they have identified a problem and have already scheduled a long-term capital improvement.
All right, well, let me give
yeah.
you a hypo. I agree with that. That makes so much sense. But suppose they're going to build a new Kevin John Bridge. And in the new bridge, they're going to put a pedestrian bike lane. But right now, there is no pedestrian bike lane. So it would be possible for them to quickly construct using wood an extension to the bridge, across the bridge, to create a pedestrian bike lane. It might cost $80 million to do it, but they could do it. I didn't hear anything in the language of the bill which takes the cost into consideration in terms of whether or not they should do this temporary fix. That's my concern.
When it says possible, I don't think that means hypothetically possible. I think
Well,
it means possible in the real world.
But it is possible. You could put an additional lane on the outside of the Kevin John Bridge. That's possible.
So MDOT is fine with the language. I think if they thought it would mandate that they have to build a whole new bridge while you're waiting for the other new bridge, they would not be in support. They and the delegate and I have worked closely with the department. I can't imagine, and they are now in support of the bill, where before they had strong concerns about the bill. I can't imagine they would be okay with the bill if they meant it to literally mean that in some hypothetical world, we'd have to build a wooden bridge while we wait for the actual bridge. That's not what this bill is saying. This bill is essentially saying, you got a 6-year expensive project, put some flex posts up to help remedy the issue in the meantime.
Might it be possible for council to draft some language which imports something about we're going to take finance cost into account in making this decision?
Well, so I'm hesitant to slow this down, but would a change from the word possible to practicable ameliorate your concern? Because that would allow us to vote the bill out, send it back, House could concur, and we could
But
move the bill.
how about possible, but adding the words without undue expense?
Practicable?
I don't care which of those words you use. How about adding the words without undue or without unreasonable expense? Adding those 3 or 4 words to it.
So we're doing this a little on the fly.
I know,
And
of course we
this is very much the baby of the delegate who's put 2 years of her life into this. And I think has come to a consensus with this department. I'm hesitant to upset that consensus. I think we could change possible to practicable. And I think practicable encompasses the cost issue that you are identifying.
All right, I'll go with practicable.
Can we just go with practicable? Would that be? It says possible.
I'm looking at the third, this is House Bill 70. I'm looking at the third reader.
So if practicable happens twice, so one is as to time
What's the cost?
and one is as to feasibility. So as soon as practicable means as soon as you can, but that's not a reference to whether the project itself is practical. Online,
Oh, got it. On line 13 or 12, whatever. On line 11, sorry. Got it. You want to change that to practicable?
I think it's.
Mine, that's what it says.
I was doing the same thing you just did. It's on line 11, not line 13.
Oh, okay. Oh, I see, yeah. All possible incremental near-term safety as soon as practicable.
Doesn't incremental get what you're doing? Does that not satisfy you?
I just want them to take cost into account. If something's reasonable, like putting up all practicable, that's fine. Practical is better than possible. I'll go with practicable. Practicable.
Oh, we're going to that amendment's adopted. Is everyone okay to adopt that amendment? All right, now the bills before you as amended. Motions for favorable with amendment. All right, everyone's okay being recorded in the affirmative.
Yes.
All right, just real quick. All right, there you go. He's doing God's work. All right, we'll come back and vote. We're doing God's work here.
Stuff at your desk, so that we're not printing out new.
Just real quick, yeah, before, we're coming back here to vote right after Flora, but real quick, just a little PSA, not really PSA, but just more kind of tender care and love. We've got, a couple long days left. We're almost done. So just everyone be kind, take a deep breath. We're going to get through the next couple days. It's going to be okay. We'll be here. Ooh, all right. All right.